Ladies and gentlemen, before the start of deliberations on today's topic, let me have the privilege as the President of NISSMAT to introduce this international institution. Established in 1990, it has now become a think tank organization with association of more than 90 experts and scholars on various subjects who provide inputs to us. Our forum has conducted a number of webinars and interactive sessions which have received massive response. I am sure our session today would be of great interest to you all. Thank you.
Good morning, good afternoon, and good evening, ladies and gentlemen. On behalf of NISSMAT, I bring to you a very important podcast today where we explore critical aspects of the India's criminal justice system. Today, we will focus on two fundamental processes in law enforcement: the general diary entry and the first information report. While both serve as police records, they differ significantly in their legal standing, purpose, and implications. How do these mechanisms function? What rights do citizens have when lodging complaints? And how do law enforcement agencies utilize them for effective policing? To help us navigate this complex yet crucial subject, we are honored to have with us DCP Laxmi Narain Rao, a distinguished figure in law enforcement. He served in the Delhi Police for over 37 years, retiring as Deputy Commissioner of Police in 2014. A decorated officer, he has been awarded multiple presidential police medals for gallantry, meritorious, and distinguished service. His expertise spans counter-terrorism, cybercrime, and legal affairs. Now a practicing advocate, he continues to contribute to law and order through his legal practice and advisory work. Today we discuss the legal provisions and significance of general diary entries and FIRs in India's criminal justice system. Welcome DCP Rao to the NISSMAT broadcast.
Namaskar.
Namaskar ji.
Namaskar to invite me for this very important podcast.
This podcast is important to the extent that everybody talks of GD entry, everybody talks of an FIR, but I don't think people understand the difference between the two and what is one and what is the other. So can you start, DCP sir, by explaining what a general diary entry is and its primary function in police stations?
Okay. Hello, sir, and to all your viewers, I must explain what is GD. GD is called General Diary, and it is also commonly known as DD, Daily Diary. Daily Diary means whatever is recorded in the police station, that is written in that diary. In Delhi, if I talk about Delhi, in Delhi there are two types of daily diary or general diaries. Number one, DDA and DDB. In a DDA, generally it is prescribed and it is ordered that all the important informations like police control room calls or any specific material which is related to any criminal case, that should be recorded in DD number 1, daily diary number 1, A जिसको बोलते हैं. Another is DD number 2, यानी कि daily diary or general diary, you can say general diary also. These both things are synonymous, GD and DD. There's nothing separate about it. And that is only meant for the departure and arrival entries of the police officials in the police station. In Delhi, I am talking about it. And that DD and GD entries are governed by our old police, Punjab police rules. That is there. And this is very important. Daily diary runs with the timing. Timing means at what time any information is recorded. That timing is very important for the purpose of any adjudication or legal provision, because once it is given, one DD entry has been given a time, the next DD entry cannot be given the time before that. That is important. So that general diary runs with the timing. When the time goes on, then DD numbers are changing and changing and changing. Once one DD entry is recorded with respect to any information, very criminal incident information, or by any police control room, or by hospital room, hospitals information, that is recorded in general diary by the duty officer. Both these GD entries or DD entries are recorded by the duty officer of the police station. There is a duty officer room in police station. They keep all these DD entries. In Delhi, nowadays these DD entries are computerized. They write all these things in computer, and once in computer it has been recorded, the time automatically captures that information. That is a DD entry or DD general diary or daily diary. This is all about it. Daily diary.
How does an FIR differ from a GD entry in terms of legal significance and procedural implications?
Yes, that is very important, because FIR means first information report. And in earlier CRPC, it was mandatory for the officer on police station of the police station, as and when he receives any report about the cognizable offense committed in his area. That is 154 CRPC, earlier CRPC. Now it has been changed into 173 BNSS, Bharatiya Nagrik Suraksha Sanhita, 173. That 154 CRPC now changed to 173 BNSS. The same thing, section is changed, but that FIR is very crucial and very important for the purpose of any criminal case. FIR means first information report. Whatever information has been received in the police station, either by telephone call or by written complaint or by any verbal information, that is to be recorded by the officer in charge of a police station or at his direction by the duty officer. They both are the same thing. But that information should be about a cognizable offense. And what are the cognizable offense? Those are scheduled in earlier CRPC, now in BNSS also. What are the cognizable offenses? They have been explained in BNSS. Those activities, those crime which has been covered in the cognizable offense, then in that connection the FIR will be registered. And the information which is not related to cognizable offense, and these are non-cognizable offense, those will be recorded as a non-cognizable report. NCR, जिसको we call in simple language NCR, non-cognizable report, that which carries no cognizable offenses committed as per BNSS.
Are there any specific circumstances where a complaint is recorded only in the GD diary and not registered as an FIR?
Yes. If any information is received in which any inquiry is to be made before registration and FIR, that is recorded in DD diary, GD. That is information which has been received, and that is required for further inquiry to ascertain its facts and circumstances. Then it is first recorded in GD, and then it is marked for inquiry to some officer, any officer of the rank, above the rank of head constable on above. That person does inquiry about those allegations, and if he finds that these allegations are true, particularly himself, or if somebody, some officer has been assigned to that GD entry for inquiry, and he goes to the informer, then if that informer gives any detailed information about the commission of crime which amounts to cognizable offense, on that basis, that officer will endorse on that GD entry copy that FIR should be registered. In that case, that FIR will be registered, and that GD entry will remain in the same place. But on the basis of that GD entry, that FIR will be registered. I'll give you some example about the FIR. How much type of FIR can be recorded and by this GD entry? Number one, if there is any telephonic information from any outside to the police station that such thing happened at such and such place, that information will be recorded in GD, and that information will be assigned to some officer, as I told you earlier, of the rank of head constable or ASI or sub inspector, like that. And that person goes to the spot where that information has, from where that information is received. And after contacting that informant or the complainant or the victim, whosoever is there, he will record his statement. And on the basis of his statement, if he found that some cognizable offense is made out of that information GD entry, then he will record an FIR. Number one. Second, it can be any information from the PCR. Suppose some PCR information is there in the police station which is recorded in the general diary, any GD. In that case also, some officer will go to the location where the offense has been found, informed as a commission of offense. That person, if goes there and he doesn't found any informer or any complainant or any victim, and for example, he found a dead body lying on the road and nobody is there to explain what type of incident was there, he only found the dead body. And in that case, when there is no person, no eyewitnesses, nothing is available for some time being, then that officer who is assigned that PCR call or the GD, he will make an endorsement, make a report about the circumstances under which that dead body is found. And if he finds that the dead body has been having injuries which are not, which cannot be inflicted by himself or by, these are inflicted by some other person, in that case, he finds that if the person is killed by someone, then he will get a FIR registered about the murder case, which is 103 BNSS nowadays. Earlier it was 302. And if some dead body is found on the roadside, and it is apparently looks like that some vehicle has crushed that dead body, in that case he will register another case of accident. In that case, and FIR will be registered under sections of accident, and the appropriate action will be taken accordingly. These are the differences between the general diary and the FIR.
Now, sir, I have another question.
Yeah.
Now, the head constable or a senior officer goes to do the investigation. They find something. Who in the police station decides whether it needs to be turned into an FIR or it needs to just be washed away?
Normally, the officer who reaches at the spot and he finds that there is something like the cognizable offense is found to be committed, then he himself decides that the FIR should be registered. But normally, he informs his senior officers, like that station house officer, he informed the station house officer about it. And in case of murder, I'm talking about Delhi and maybe in some other states also like that. If there is a case of murder, then that head constable or ASI or sub-inspector will not investigate that case. Only he will make an endorsement for the registration of FIR, and then he will request to the SHO or any inspector of the police station to investigate that case. Because in murder case, there are orders of senior officers and police headquarters that murder case will be investigated by the officer not below the rank of inspector. He may be additional SHO investigation, or he may be additional SHO law and order, or he may be SHO himself. The murder case will be always investigated by him. So far as your question is concerned, the officer in charge who is deputed to visit to the spot, he has to decide, and then he has to reconfirm or seek approval of his SHO for doing so. That is important.
And thank you very much. Very important for me, because sometimes we feel that the local police officer should be able to record an FIR, whereas he still has to seek approval from his boss.
That approval is formal approval, because he has to inform that such type of thing happen and I am going to do that thing. And not exactly that if he SHO, normally the SHO should not refuse to get an FIR registered, because if there is any offence is committed, cognizable offence is committed, we need to have an FIR registered for that, for further investigation. And section 154 CRPC and 173 BNSS says that as soon as the FIR is registered, the investigation will be started by that officer in charge, investigating officer. That the person is called, earlier he was called EO, inquiry officer. Now after registration of FIR, he will be called as investigating officer. Then the investigation will be started immediately after the FIR is registered. And investigation should be done on day-to-day basis without any delay. This is provision of law.
So is it mandatory for the police to register an FIR for all cognizable offences? What happens if they refuse?
Yes, that is very important question. In all cognizable offences, it is mandatory to register an FIR and then start investigation. If in case there is a complaint about any cognizable offence and police does not register an FIR, then there is another channel open for the applicant or complainant. Number one, if the complaint is made to the station house officer and he doesn't think it proper to register an FIR, even then, even if the offences which have been explained in that complaint are of nature of cognizable offence, and he does not register the FIR, then that complainant or informant should contact his senior officers. Senior officers of the SHO, maybe ACP note, but in that case, provision is that he should contact the DCP and give a writing that, look, I have filed this complaint to the SHO of the concerned police station, and he did not register the FIR in spite of the fact that cognizable offences have been found to be made out. Then the DCP will look into it, whether if he thinks that the case should have been registered, then he will direct the SHO to do that, to register an FIR. But if he still thinks that there may be some fishy about in this complaint, then he may not. He only asks the SHO to inquiry and report. Yani, give me some details about the complaint and why this case could not be registered as an FIR. In that case, the SHO will report to the DCP about that, and on the basis of the complaint of the DCP, complaint made to the DCP in this regard. And after that, if SHO also does not register an FIR and DCP also does not think it proper to register an FIR, then that informer or the complainant has a legal right to approach to the concerned magistrate, that area magistrate, that is under section 156(3) of CRPC. Then he can report, he can give a written complaint or application to that magistrate that, look, I have given this complaint to the SHO, and further this complaint was also given to the DCP. Even then my case was not registered and investigation was not started. Then that magistrate will ask for the report from the SHO concerned. You give me the report about it. That is called ATR. ATR means action taken report. What action you have taken about that complaint and why this case was not registered. Then SHO will submit a report to the magistrate. And in that case, if magistrate thinks it that yes, report of SHO is quite reasonable and he was justified not registering the FIR, there may be two reasons. There may be two aspects of that. One, the report of ATR of the SHO will be seen by the magistrate, and if he still thinks that SHO is not correct, then he will make an order to register an FIR, direction to the SHO. He will pass an order that directing the SHO that you should register an FIR, start investigation. That is one part. That is under section 156(3) of CRPC. And in that case, if he thinks that in this case FIR is not required to be registered, then he can inform the complainant that yes, okay, no problem. If FIR is not registered, no problem. You bring evidence before me, then I will record the evidence. And if found correct, then if it is found that yes, something wrong has been happened to you, then I will summon that accused after recording your evidence. In that case, that is called PSE, pre-summoning evidence. That pre-summoning evidence is recorded by the magistrate on the basis of the evidence given by the complainant. That complainant whose complaint was not registered by the SHO and DCP, and it was not converted into FIR. Even then, the magistrate will do that inquiry, and during that inquiry, he collects that evidences given by the complainant, and after that, if he is satisfied that yes, offense has been committed, then he will call for the that he will summon the accused persons who has, against whom that complaint is made. Then those persons will be summoned and accused, and after that, the trial will start against them. This is the legal provision of when the police does not register an FIR.
Sir, one more thing. What is the zero FIR?
Yes, that is very important. Zero FIR. Zero FIR is lodged by the complainant or a victim in any police station, irrespective of the jurisdiction. For example, someone has lost his someone has been injured by some bullet or some knife or something like that in the area of, say, like Arkepuram, and he lives in area of Janakpuri, for example, I am saying, and because he lives there, and he, after being beaten, he went to his house or went to the hospital, and then he did not report to the police, and after reaching his house in Janakpuri, he lodged a report to the police station Janakpuri. But that offense was not committed there, but it was committed in Arkepuram area. Then in that case, the police will record the zero FIR. That FIR will not be given any number, and that FIR will be recorded as number 0, and that FIR will be transferred to the police station Arkepuram, where the actual offense was committed. That is the meaning of zero FIR. Now, in new BNSS, that is online FIR, there is a provision of recording online FIR. Even that also, in some cases, when the people, zero FIR concept came because of that, so many people doesn't know what is the jurisdiction of a police station. Once offense has been committed anywhere, how does a common man will know that this will fall into the jurisdiction of this police station? So any person is authorized to report to the nearest police station about any commission of crime committed against him anywhere in Delhi or anywhere else. In that case, that police station where the report is initially registered, having no jurisdiction of that offense was committed, that he will register as zero FIR and send to the concerned police station for further investigation.
So who can lodge an FIR? The aggrieved person or somebody on behalf of the aggrieved person can also lodge an FIR?
Any person who is having knowledge about commission of any cognizable offense can lodge an FIR. Maybe aggrieved person, maybe his relative, maybe any other person. For example, if someone is going on a road and he sees that some accident has taken place and some person has died on the spot, or he has been injured and moved to the hospital, that person who is neither the victim nor related to the victim, but he is an eyewitness, he can inform the police and he can also get a FIR registered. Similarly, any person who is not at all related to the victim or any person, but he has seen that he must be the eyewitness of that incident, he can register an FIR. There is no hard and fast rule if the FIR, whether the FIR is to be registered by only the victim or his family. Anybody, any person who is in the knowledge of commission of offense, that can be registered as an FIR.
Another question. If I own a factory and there is a theft in my factory,
yeah,
who is empowered to lodge a complaint or an FIR saying that I have lost so much of saman? Is it the duty of the security company to do so, or it is the duty of the owners to do so?
So it depends upon if the first responder, if somebody sees that the factory has been burgled into and the owner is not there in the factory, maybe it was burgled in the night. Somebody broke on the lock and went in the factory and take away all the goods. And the security people deployed there, they see that it has been happened. Then they should inform the police control room immediately after that. Number one, he can report the police control room, and after getting the information from police control room, on the basis of the information given by the security person from the sport, then that information is, as I told you earlier, that information is passed on to some inquiry officer, and then that inquiry officer, he will contact to the owner of the factory. Then that owner of factory will assess what are the losses, and he will lodge a report about it. Security man's duty is just to inform the owner or somebody else or to the police. He cannot access what type of losses has been taken place. Only the information about the losses caused or the quantity or quality article stolen, that can be revealed by the owner or the manager of that factory. So they will get a FIR registered.
Now, can a GD entry serve as evidence in a court of law, or is it only an internal police record?
No, as I told you, GD is also connected with the criminal jurisdiction system, because GD is also part of the charge sheet. Whenever it is any charge sheet is found, then that GD entry is also part of the document which is enclosed with the charge sheet of that particular case, because that is the first information received in that case, GD. Moreover, in so many cases, the courts have observed that FIR is registered subsequent to that GD entry, but the information received in GD, that is the prime importance information, and that is considered to be the most true information. So that GD entry with respect to the offense committed, cognizable offense committed, that is relevant and that is part of the charge sheet. Not only the internal police record, but that departure and arrival entries, they are the internal police record for the purpose of the person went to some duty or came back from the duty. That is the internal. But in that case also, when the departure and arrival is with respect to any cognizable offense, with respect to any offense committed by someone, in that case, that part of GD entry of arrival and departure, that is also very important, because in some cases it is found that the police, if the police has made a false case, false investigation is done, saying that I went to some other place, but that should be, that claim of the police officer should be supported by his departure entry from the police station and arrival entry from the police station at the particular location at the particular time. When he claims that I went to investigate this thing, I went to such and such place, and if there is no departure entry in this regard, then his claim will be falsified. So in that connection, departure and arrival entry and any GD entry about any information about cognizable offense, these are all relevant to the criminal justice system. These are used in the trial.
Are these GD entries public information, or they are held closely to the chest by the police?
No, these are not public information. These are the police documents. These are utilized by the police while preparing charge sheet, and these are made relevant entries are made part of the charge sheet whenever it is required, and the case is sent for trial.
But if the defense counsel needs to have a look at the entry of departure and arrival, can he do so?
There are two things in that. Once any GD entry or FIR or any document is made part of the charge sheet, then the defense counsel has a right to get all these documents free of cost, that is which are enclosed in the charge sheet. That is not that is his prerogative, and that is his legal right also. But in some cases, if those documents are not part of the charge sheet, then that defense counsel cannot, as a matter of right, seek that DD entry, departure or arrival. But I also let you know that it can be revealed by getting RTI information. If you apply for through RTI, then the police is bound to give that information. But in that case also, police can refuse to give that document if the case is pending investigation or if the case is pending trial. There is a provision of in RTI also, that section 808H, that in that case, police can refuse the information or document to be given under RTI if those documents are related to any investigation or trial.
Now, sir, can an FIR be withdrawn or squashed?
Yes, FIR can be withdrawn. In that BNSS, there is a schedule that is called which offences are compoundable. In that case, FIR is not withdrawn, but that offence mentioned in the FIR can be compounded. There are sections in which it is stated that the some cheating has been done with someone, some person has been minor injuries has been committed to him. That person who has been cheated or who has sustained some injuries by some person, and they both compound, that the person who says that okay, galti hogi, then in that case that complainant can compound that offence before the court. That is done before the concerned court, maybe magistrate court or maybe sessions court, wherever the case is under trial. Whereas the quashing can be done only before the High Court of that area. High Court means so in that case quashing can be done mainly on the basis of two things. One thing, that in the case which is not covered under compounding offences, in that case the person, if they are mutually understanding and amicably settle their issues, then they both go to the High Court, before the High Court, and give a settlement deed that look, our differences have been settled amicably, we are settling this amount, we don't want that this complainant don't want to pursue that case further in trial. In that case, High Court pass that FIR. In that case, no case can be tried after that, after quashing. Another thing that is between the two, the complainant or the accused. In that case, when the mutual understanding is there. If there is no mutual understanding, and if still the accused finds that alleged person finds that this case has been wrongly registered, and there is no requirement of registering this FIR, that has been registered without any legal provisions, and that was malicious FIR. In that case, he can go to the court, High Court, with a request to quash that FIR on the basis that this offence was not made out, this legal provision was wrongly attracted in this FIR, and in that case, if the Honorable High Court judge finds that yes, he is right, then he can quash that FIR also. But in such type of cases are very rare. You can say only 4 or 5% cases can be quashed on merit. On merit, generally the FIRs are very rarely quashed or cancelled. Only in those cases when the case has been registered by malicious intentions or wrong sections of the offence have been lodged, like civil matter has been made a criminal matter. Suppose I want to seek some, I want to need to recover my money from someone. It's a civil matter. That recovery of money can be sued by the civil court. But if I give it color to the criminal case and get an FIR registered, and in later stage when that accused persons went to the High Court and say that it was a civil matter and it has been given a color of criminal case, then if High Court thinks that he is right and it was not required to be registered as an FIR, then he can quash that FIR, considering it a civil matter.
What happens if you lodge an FIR based on false evidence? What are the penalties for misusing or lodging a false FIR?
Yes, there is a provision in law. If you lodge a false FIR against someone, and during investigation of that FIR, the investigating officer reaches to the conclusion that no such offense was committed and the allegations leveled by such person are false, and he made it intentionally, maliciously, or as a matter of taking revenge, then in that case, that investigating officer may cancel that FIR himself, may cancel. He can write a cancellation report in that FIR, giving all the investigations done by him, that what type of investigation he did and why he reached to the conclusion that this offense was not committed. After giving this all reasoning, he prepares a cancellation report, and after getting it signed by the senior officers, he sent it to the concerned court. And after that, in that cancellation report, he also writes that because the case was falsely registered by the complainant, an action should be taken against him. Action under section 182 of CRPC can be, 182 of IPC, giving false information. That 182 IPC was earlier in IPC. It says that if someone reports to the any government agency or like police to inform falsely, and so that government machinery comes into action, and during investigation it is found that the information given by that person was false, wrong, malicious, intentionally did wrong information, gave wrong information, then that person should be prosecuted under section 182 IPC. But that 182 IPC is also a non-cognizable offense. That can be that action can be recommended by when the magistrate writes that 182 proceedings should be initiated, only then it can be done. So that cancellation report carries that information also, that the action should be initiated against the informant or the complainant under section 182 CRPC. Then that magistrate sees all the circumstances and pass an order that the case is, that FIR is cancelled and the action against the complainant should be taken immediately in that case. Then the police takes the action in that matter. And that person who has given a false information is sent to the trial for that offense.
In a lot of cases, Rao sir, it is generally seen that people hesitate in approaching the police for any grievance that they have. Sometimes it is felt that when they go to the police station, the police may not be of help, but they may just target the individual himself. How do you overcome this? What are the soft skill trainings that are necessary in the police department today?
That is called grievances redressal system in the police station. That sometimes police with some malicious intentions, some because of some obvious malified intentions, they lodge false report against some person, and for taking gratification or something else, or taking revenge, or at the instance of some other party, they can do that. They do that, and such incidents when come to notice, and that person, aggrieved person, can approach to the senior officers. There is a mechanism that senior officers can hear the grievances of such aggrieved person in the hierarchy. Like in police station, after that is the ACP of that area, Assistant Commissioner of Police, and after that DCP, Deputy Commissioner of Police of that area, and even after that then Joint Commissioner of Police of that range. Then he can approach to all any or all the officers if he thinks so. For overall state like Delhi, or for overall state like Haryana or some other states also, there is a mechanism of vigilance branch. In vigilance branch, some person can go and directly they can report to the police against the police. Mainly the vigilance branch is created to investigate the allegations against the police officers who are involved in moral turpitude, who are involved in corruption cases, who are involved in asking the gratification, or who are involved in the malicious prosecution, lodging false report, false FIR against some person, which is not required to be done. So in that case, there is a mechanism of grievance redressal, and in that case, inquiry is conducted by the vigilance branch. Even in district level also, there is a vigilance branch. Even at the police headquarter level, there is a vigilance branch. But the jurisdiction of these vigilance branches are bilkul different. District vigilance branch will investigate the complaints of grievances of the their own district area, and the police headquarter or overall Delhi vigilance branch will be having jurisdiction of overall state. They can investigate or inquiry any person who is posted in that state, like in Delhi or Haryana or somewhere else. So there are a double layer of vigilance branch having the grievance redressal system.
Now, sir, a lot of digitization is taking place in the country. What is the level of digitization in the police stations in Delhi? For example, how digitized have they become? Lodging of FIRs on computerized system? How's the tracking done? Can you throw some light on this particular aspect?
Yes, Ahluwalia Sahab, there are now there is a need of our to digitize the record, as well as the doing all computerized system investigations or working in the police stations also. Now recently, till I retired before 10 years, in 2014 I was retired. I retired in that area. That time that the process of digitization was in progress. Now it has been, I think, almost more than 60% police station working is digitized. Like I told you that FIR is registered online, FIR registered computerized, GD, General Diary registers are recorded by computer, and investigation, while doing investigation also, the case diaries are also written by the computer. Every investigating officer is being provided with a laptop, and he makes his own notes about the investigation done. That is called case diaries. The CDs, in brief, we can say. Case diaries means whatever he has done the investigation, that is recorded in case diary. And that case diary is a part of the investigation. When the case is sent to the court for trial or for cancellation or for entrance, those case diaries are accompanied with that case file. So this is very important, and it is necessary also, because earlier there was a lot of record which was weeded out, because after that there was a provision earlier when the record is compiling in the police stations. Then there was a provision that the order was made that such and such things should be weeded out. It means destroyed. That these documents which have been very old, so that they can not occupy the much space. But FIR cannot be, that old FIR cannot be destroyed, that cannot be weeded out. Because if you find that what is the, which is the FIR registered in the, when the Delhi state was made, like in 1861 when Delhi Police Act was made, then you can find the FIR right now also, written in Urdu. At that time, FIRs were being recorded in Urdu in handwriting. Now this is totally changed, that the computerized system is there. And the second part is, in addition to the record keeping also is computerized. And another thing, that the Malkhana, this is called as general store also of the police station. Now the Malkhana has been also divided into two parts. One part is the case property Malkhana. One part is government property Malkhana. So GPMC or the government property GPMC. So these Malkhana has also been divided into two parts, and that is also computerized. The record, the Malkhana Mohorar, that is called Malkhana Mohorar, who is in charge of that keeping safety and security of the case property or the government property. He uses that computer and he make entries in that computer. Secondly, all weapons which are kept in the police station, that is also computerized. Everything is on the click of mouse. So digitization is very important, and it's taking place as and when required. It will be improved also. Day by day, we are improving that process.
What are the proposed reforms in our police system to make the FIR registration system more transparent and citizen friendly? And also, secondly, if I want to know if a particular FIR has been registered in a particular police station, can a normal citizen do that?
Yes, yes. Recently, not recently, it was about 4 or 5 years back. Honorable Supreme Court has passed an order that every FIR registered in any police station, I mean anywhere in India, that should be uploaded in the website of the police. Police. After that, every police station, every state police has their own website. Like in Delhi police, delhipolice.gov.in. Like in Haryana, every police has their own website, and in that website there is a field that view FIR. If you go to view FIR, you can see that is there are some parameters are there. You need to know the FIR number. You need to know which year that FIR number is that. Then you can view the FIR. But this is a common order that every FIR should be uploaded in the Delhi Police website for viewing of any person anywhere in India, anywhere in world. Anybody can view. If I want to see the FIR registered in Tamil Nadu, I need to know the FIR number, police station and district and year. 4 things are required: police station, district in which that police station falls, FIR number, and the year of FIR number. I can click that FIR and print it out at my residence. But in that case also, there are some offenses which are not allowed to be uploaded. Or FIRs which are related to the women, like rape, molestation, or FIR which are generally of the national interest regarding some terrorist activities and so many other such things. These are not allowed to be uploaded in the website of any state police. And another thing also, any other FIR which are required not to be uploaded with the approval or with the permission of the district DCP or district SP, that FIR can also be held from viewing the in the online. This is the provision about the viewing of FIR in general and in particular.
How does the FIR system vary from state to state within India?
Yes. Every state has a format of registering an FIR. Their own format is there. In Haryana, I find a very lengthy FIR, having very lengthy format. In Delhi, it's not so much lengthy. Main information is in kept in only 1 page, and then the rest of the information is recorded as per the complainant's information. And in Haryana, you can compare, you can see, it all depends upon the requirement of a state. What type of police officers of that state want the information to be recorded in which format, they design that format. But obviously, there is no uniform pattern of FIR in every state. Almost all the states have their own different pattern or different format of registering an FIR. But basic thing is that the FIR is registered only in the where the cognizable offences are found. Then only that FIR under section 154 CRPC, now 173 BNSS is recorded.
Last question. What advice would you give to citizens of our country regarding their rights and responsibilities when interacting with the police?
Yes, that is very important aspect, because the public is more interested to know about all this, their rights also. Because the general public is afraid of going to the police station. Even what to call about the general public, even I being retired officer, I also hesitate to go to the police station. But if something happens, then we have to do that. But without fear, without any apprehension that the police will misbehave with you, you must go. And if it is required, of your requirement is going physically there, then you must go. If it is not required, then under the new BNSS system, you can record any FIR online, and after that, not only immediately you should go. Within 72 hours, you can go to the police station and only sign that what you have given in writing. So number one point is that we should not afraid of police. And for police, I also advise that they should be people friendly. They should not harass the public when they interact with them. Generally, there are complaints that police harasses the people and they don't talk so politely with them. That should not be the complaint. That the police officer should think that anything can happen to anyone, and if the police officer in place of that victim, then he will think about what he should do, what he expects from the police. He should replace himself in place of that victim who goes to the police station, and at that time that police officer will require from that police. That should be the idea. And in that case, the police as well as the public should be cordially doing their duties or doing their seeking their rights, both any duties by the police and seeking their legal rights by the public. They should go in tandem and mutually. Particularly, the victims should not be harassed, and police should behave with the victims very politely, thinking that he's in the mental trauma, because any person who has been victimized of any offense, he is definitely under the trauma or under the any amount, you can say, amount of fear, or his mental situation is also not proper. Then he should be given some relax, and then he should talk with him. So, and for the legal rights of every citizen, they must know. Nowadays, you can go to any, you can Google search, then you can find what are your rights. And the young generation of today, they are seeking the help of that internet or the internet, and they're seeking their legal rights online also. And by watching these social media informations, newspapers, media informations, nowadays the time is changing. It is not like that earlier. Whatever the police was doing, that was correct. Now, if some police officer is found to be doing something wrong against any victim or any citizen, that should be reported to the senior officers immediately, and that person should be dealt with by the police as per law, as per their requirement, as per rules and regulations, so that the public should feel safe themselves, because we, the police officers, should be for the public, and public should feel themselves safe in front of police. When this stage will come, when we see the police officer, then we will not afraid of him, and we will consider him as our friend. That will be the golden time for the public, and I expect that should come.
No, you're very right. The police should be friends of the public rather than the public being scared of the police.
Yes.
Today's discussion has shed light on crucial roles of the general diary and FIR system in India's criminal justice system. While a GD entry helps maintain records of daily occurrences, the FIR sets the wheel of investigation into motion. It is essential for citizens to understand their rights, the obligations of law enforcement, and the legal recourse available in case of non-compliance. I thank you, DCP Ellen Rao, for sharing your insights and expertise. I'd like you to sort of look out for more conversations that we have on the law, justice, and governance system in our country. Until next time, stay informed, stay vigilant, and exercise your rights responsibly. Thank you very much.
Thank you, Ahluwalia Sahab. Nice to see you. Thank you very much.